Please, Your Lordship. Lordship, I beg to mention an IA for listing next week, Lordship.
When?
Next week, any date, Lordship.
Next week. All right.
Obliged.
IA in criminal appeal.
Yes, sir.
May I please, Your Lordship? Lordship, I beg to mention for listing of a criminal appeal for orders column, my lord, next week. Much obliged.
Next week, Wednesday.
Yes. Obliged, my lord.
For orders, item 1. Service was to be done on the.
No, it was done. It was served. I have given the acknowledgements, my lord.
Anyone
Copy got
appealing?
it, na?
Anyone appealing?
No. Nobody's name is shown, my lord.
We'll have to appoint an amicus, I suppose.
Yes. But other day, this honorable could observe, since copy was served, they are not like, they have not come up before anybody that for like engaging any lawyer and for free service. So in that event of the matter, it may not be required.
No, only
Yes.
because of the earlier order passed by the division bench.
Yes.
that
Deepak Nayak.
Copy served.
Copy has to be served. Lordship, may kindly have a look. Probably engaging a lawyer may not be necessary. Asana,
Because it is a FOXO matter.
yes, my lord.
Yes.
All right, then we'll, the paper books are ready.
Yes, my lord, sir.
We'll fix it for hearing.
Well,
Lordship, may kindly have a look at the notification number 17. Did you? Asana.
No, this is pursuant or the question of the chances of acquittal.
Lordship, I have annexed all the repositions.
You have annexed, but we need to have the paper book ready. In the criminal appeal, you write, I heard counsel for parties, the LCR call for has been received. The registry will,
Now it is TCR, your lordship. Trial code.
trial
records.
court, TCR. We belong to the old.
Yes,
school,
my
we are
lord.
not used to-
Same here.
The trial court records have been received and therefore the registry is directed to prepare the paper book as expeditiously as possible.
Lordship.
Matter be listed after 3 weeks.
Lordship may fix the date after 3 weeks. Lordship.
The IA to be considered on the next date fixed. Twenty-seventh
My lord.
August.
Lordship,
27th August.
DP, your lordship.
Items 3 and 4.
Train profile, yeah.
Wait, please, Your Lordship, I mean, item number 4.
Yes, sorry, number.
But he was convicted under 20B2C commercial, my lord, and he was filed an IA, my lord, for suspension of
Really,
sentence.
this objection.
You are referring to
Yes.
the IA.
Yes, my lord.
IA.
Objection.
Or in item number 4. Okay.
Item
What is that?
4.
Item what?
You,
And number 1188888/23.
Lordship, actually,
Objection not filed.
he said it was filed, but I don't have any records with me today, unfortunately, my lord. Can it be taken up in the coming week?
the objection is here.
My lord, 5 years is behind the bars, my lord. This matter was adjourned on last 2-3 days on the basis of this objection only. ma'am.
When did it file? Did you file, Gulson?
It's here, madam. It is
Lordship, but I don't know who has filed
Alright.
it.
filed by someone, it's filed in 23 December.
Yes, my lord.
We'll have it
They-
next Tuesday. You get a copy?
From him only and
No, you get a copy from here if it's
Fine.
possible. It's an objection filed from the
from the
state.
state, yes.
So we'll request the court master to hand you a
Lordship.
copy.
Along with appeal memo. Actually, no papers
Nothing is
have been,
there.
nothing. By the office concerned, my lord. It was not available today.
Well, the records are here. You can go through the records.
Lordship.
In IA number 1188. You're Mr. Mehdi.
DK Mehdi.
DK Mehdi, counsel appears for the applicant. The state has, the learned APP has filed the objection. So, how MS B. Mia, learned senior counsel, additional PP submits that copies of the case records are not available.
Yes.
Copies of the case records, including the objections filed, are not available. So, Mr. Mehdi, on the other hand,
Yes,
submits
okay.
that the matter has been adjourned on several occasions, only on the account of the objections. Stop.
Lordship, he also needs the paper book to be prepared.
Hmm?
Paperwork, my lord.
Needs to be prepared.
Prepared, my lord.
Then maybe taken after preparation paperwork.
Meanwhile, the criminal, accompanying criminal appeal. LCR received, na?
Lordship, TCR.
TCR received. Therefore, the office to prepare the paper book within 3 weeks. Matter be listed thereafter along with the IE.
Lordship.
Lordship, in item number 3, Lordship, I am appearing. Lordship.
In item 3, Mr.
DJ Boro, Lordship.
DJ Bol. Same order.
Problem.
Number 4.
Come forward. Item 4, Mr. Mehdi is
It
appearing.
is appearing. Maybe single benches matter, maybe she's confused.
You sort out between both of you.
Yes, Lordship.
Item 5.
May I please, your lordship?
Okay, it's right.
Instructions regarding informant.
Pokso निकले. इसलिए नहीं. Copy नहीं. Copy दी बोलेगा. Copy दी.
Objection confirmed.
Yes.
My lord, objection has been filed, my lord. But paper book is not ready, and regarding informant. POXO matter. ma'am.
Paper book
Paper
Has
book
to be prepared. Has to be prepared.
appeal has already been admitted by order dated 5/2/2025. The TCR call for has been received. Office to prepare the paper book as expeditiously as possible and matter be listed thereafter.
Public.
Based on, have it on 9th, let us see, 9th September.
Item 7.
Second.
Yeah, please, your lordship. My lord, this is, my lord, under section
Oh, oh,
POXO, my lord.
Service is
Not- Service is not yet complete. Not, I have taken the step, my lord, on 21/3.
Yes.
Lordship, in this matter, Lordship, for today, short accommodation I require. I did not get any instruction from my client yesterday. I could not contact my client.
What is these appeal?
This is the revenue appeal by the
250.
260.
Against what?
Not say against order dated 9/10/2020. Substantial was framed on 9/9/21.
Substantial, what are the substantial questions?
Not see one whether the conclusion of the landed tribunal that the notice issued under section 147, 148 of the Income Tax Act was invalid is perverse, nigh of law. And therefore the influence judgment called for reversal.
By which order?
It is by order dated 9/9/21.
9/9.
Yes.
'21.
It's a long pending matter. 21. Let's say in the meantime, let's say the appeal was dismissed for default. Then again it
Whether
was,
the conclusion of the. This is 147, 148.
let's see. Let's say tribunal on basis of some judgment passed by the Nagpur bench and Bombay bench, court had decided that 143 is if the order is passed.
No independent
not-
inquiry.
Yes.
What is the ground?
Lordship here, subsequently Lordship, they relied on judgment that is based on assessment year of 61-62. Thereafter, the income tax was amended. And in the meantime, Allahabad High Court passed an order that is applicable in this.
For which assessment year is this order?
It is assessment year
2013, 14.
13-14.
13-14. So this
Yes.
is well after the amendment.
Yes, sir. This is our contention.
So the only requirement is the availability of materials to see that
Yes, Lord.
Lord-
income has
Lordship,
escaped assessment.
yes, Lordship, the matter was heard, though it was, the other side was not present. The earlier division bench relied on a decision and dismissed the matter. Thereafter, it was restored again.
Why?
Restored at their instance, Lordship, at the instance of the government.
It's in absence of
This
the.
is an
council.
appeal by the revenue.
Yes, Lord.
Yeah.
Ah.
Basically, Lordship, assessment,
If my learned friend wants to argue, Lordship.
Lordship, I seek an accommodation. Lordship wanted to know the facts.
So ultimately, it was dismissed, disposed of on merit or on
No,
non-proceeding?
on the dismiss for default because counsel for the department not present on that day. And relying on one judgment placed by my learned friend, the appeal was dismissed. But that judgment is not applicable. While restoring will place demonstration before this honorable court on finding them sufficient metals, case was again restored laws. And thereafter matter was listed many times. My learned friend on every occasion lordship take time to take instruction from the miscreant.
It's a covered, issues are covered. Question of law, this is only if this is the only question of law, it is covered by so many judgments.
Lordship, I'll demonstrate lordship, if my learned friend ready, I can place before lordship.
Lordship will fix a date, Lordship, any date Lordship fixes, I will argue the matter.
Mr. S.C. Kayal appears for the appellant and Mr. B.P. Bora appears for the respondent. Mr. Bora rainfall is granted 2 weeks. At the instance of Mr. Bora, matters still deferred, we listed on.
Much appreciated.
Still, sir, still working.
Yeah, working.
So where is the urgency?
He is not paying salary, my lord,
Huh?
salary.
Calendar on to the offer, what? और ये वाला कैलेंडर यहाँ लगवा था बाद में हाँ Monday.
Monday.
Monday is not possible. We'll have it on 18th.
May I place a abject myself for listing my lord, contempt case, my lord?
18th.
Yes.
No, please, Lordship. Lordship, I'd like to mention item number 5, Lordship. My senior, Mr. M. Chandra, has some personal difficulty, Lordship. Lordship, may kindly adjourn the matter for today and may fix any date next week. We have taken consent from the other side, Lordship.
Sorry, 14th.
What obliged?
Item 5, 14th.
Lordship, I appear for the response.
Mr. D. Bora appears for the respondent. Yes.
Item 1.
Is your lordship?
Yes.
Lordship, both our seniors are on legs before court number 1.
Lordship, after some
It has already been argued, is that
caste certificate.
caste certificate, caste, reopening of their matter.
Yes, Lordship.
Is anything more left to be submitted?
Lordship, my senior would like to make some submissions, reply as a reply. Lordship, may I fix it?
Let us have it on 21st. 21st August.
Lordship, there is an APSC hearing matter in that day fixed. Lordship may have it on the 13th if possible.
No, this is what about 19th?
Yes, Lordship.
Lordship, 19th. 19th would be fine.
Yes, 19th, list on 19th. On the joint request of the parties. 19th August.
Much of.
Item 2.
Lordship, reading entries matter, Lordship, otherwise, Lordship had heard it, only Lordship asked for some clarification that whether before issuing the impugn order,
We'll post this matter on 12th. There is one judgment which is likely to be delivered next week on reading. Go through it and then we'll see whether it covers this matter or
Lordship's judgment.
yes. Since this is a parted matter, so it's better that the judgment gets delivered first on the same issue, whether reading will automatically require discharge, etc. List this matter on 12th.
Items 3 and 4.
Okay.
It was a photocopy. Yes. Yes, Mr. Chetwin.
My letter here, this petitioner number 1.
Hmm.
She is a wife of the deceased, this Sanjeev Kumar Kalwar, the petitioner number, in case number, this item number 4, madam. Item number 4, this was the Sanjeev Kumar Kalwar. But when the matter was pending, he expired. Now, my lord, this wife has come for pensionary benefit and all. He was removed from service, my lord. First is
Who's for the respondent?
respondent Gupta.
TGC.
Yes, S. Gupta.
H. Gupta. H. Gupta. CGC. Yes.
My lord, here, firstly, my lord, this petitioner, my lord, this petition number here in the item number 4, my lord. Item number 4, my lord. Since on the day of 3/7/2019, he got serious ailment, my lord, and because of this dysentery and fever, all this, he immediately went to home, my lord. The home is very nearer to the Likavali camp, my lord. And it is hardly from Likavali to my home, it will be 5 km distance. And in between the Silapathar town is there, my lord. And of course, this person, my lord, just my next door neighbor, this person. Here, my lord, on 3/7/2019, in the evening, he got abdominal pain and he could not report for duty. Thereafter, considering his serious problem for his ill health, he came to home. And on 5/7/2019, he was treated at Dhemaji Civil Hospital. And after due treatment, it was found that he was suffering from acute jaundice. Now, my lord, the action has been taken. Then, my lord, totally 176 days, the absent period was shown, my lord. Now, lordship, in the notice sent by them, my lord, in the wrong address, they have sent the notice. Lordship, kindly have a look. My medical documents, my lord, lordship will find annexure start from A2 up to page 19. From page 19 to it is up to page 30, lordship. My lord, lordship, kindly have a look. This annexure F, the order, my lord, deserter order, my lord. Page 34, lordship. Here, lordship will find the address at page 37, lordship.
Which page? Page 34 is a part of paragraph 11.
Page 34 is a deserter order, my lord. They have
34 of
uh,
the writ petition.
writ petition.
Writ petition 3245.
Yes.
No.
No, this, item number 4, lordship.
Item 4. Yes, 34.
34. This is the deserter order 7/9/2019.
Mhm.
The Sanjeev Kalwar was deputed so duty transport, Likavali and movement order for his shifting from the transit camp to the battalion headquarters in the afternoon 3/7/19 was issued, but the official has not arrived at the battalion headquarters till date. The official has remained absent from the duty without the permission from any competent officer. By letter number 16/7/19 of the official was directed to come to the battalion headquarters immediately. The copy of the letter was also furnished to the father of the official with a request to send his son to the battalion headquarters immediately. The official has been absent from his duty since the afternoon 3/7/19. That is for 15 days without obtaining permission from any competent officer. A judicial inquiry committee was constituted by order number 4403 dated 5/8/2019 of this office as per the provision of section 47 of ITBP Act 1992 to know the cause of continuous absence of the official. As per the judicial inquiry, Constable GD Sanjeev Kumar Kalwar remained a deputed in the transit camp Likavali for LO duty, liaison officer duty. An amount of rupees 22,646 and 75,635 was deposited on 22/10/2018 and 27/2/19 respectively by Pioneer Branch in the account given by CGD Sanjeev Kumar Kalwar for the payment of area electricity bill of the transit camp. And on 22/5/2019, I, Sonja Aziz Khan, gave an amount of rupees 34,924 to ASI GD Raghuvir, the then in charge of transit camp, while giving the amount of rupees 34,924 in case to CGD Sanjeev Kumar Kalwar. ASI Raghuvir directed CGD Sanjeev Kumar Kalwar to pay the electricity bill of rupees 1,33,205. Since the official was called for the battalion headquarters by WT Messrs. So-and-so, 2/7/2019 of construction branch due to non-payment of electricity bill in full, the then in charge of transit camp issued movement order for the movement of the official from transit camp to the battalion headquarters in the afternoon 3/7/2019, but the official has not arrived at the battalion headquarters till date. Meanwhile, the official has paid electricity bill of rupees 1,20,000 and the receipt of which has been received by the battalion. The official has not paid the paid back the remaining amount of rupees 13,205 to the engineering department till date. As the official remained continuously absent from his duties, the Central Records Office was requested through email number so dated 16/7/19 of the office to hold up the salary of the official, and through letter number 99 dated 5/8/2019 of this office, the Superintendent of Police Dhemaji, Assam, and officer in charge Silapathar Police Station, Dhemaji, were requested to arrest CGD Sanjeev Kumar Kalwar and hand him over to nearest battalion regional headquarters, ITBP, Likabali. But neither police has arrested and handed him over to the regional headquarters, Likabali, nor has given any information to this office. Force number so-and-so Constable Sanjeev Kumar Kalwar has been absent from his duty since the afternoon of 3/7/19 without obtaining permission from any competent officer, and has neither sent any letter with regard to the absence nor has contacted the battalion headquarters, which shows his negligence and indiscipline. In view of the opinion of the Judicial Inquiry Committee, statement of witnesses and available papers and documents, I have to come to the conclusion that though the official was directed to arrive at the battalion headquarters by letter number so-and-so 16/7/19 and 99 dated 5/8/19 of 14 battalion, the official has not come back to the battalion headquarters, that he has been continuously absent from his duties, which shows his negligence and indiscipline, and it becomes clear that the official is not willing to serve in Indo-Tibetan Border Police. In view of above facts and circumstances, force number so-and-so, Sanjeev Kumar Kalwar, is declared a deserter from the afternoon of 3/7/2019, as per the provision of section 74(2) of ITBP Act 1992. It is ordered that the remaining amount of electricity bill of rupees 13,205, which the official should have returned to the battalion, be adjusted from his salary and deposited in the fund of the battalion, and an amount of rupees 3,030 for the official uniforms and other things issued to the officer be also adjusted from his arrear salary and deposited into the offices of the government. Now, Lordship will find this the below post number so-and-so Sanjeev Kumar Kalwar, father's name Dilip Kumar Kalwar. Now, next page 37. The date of joining so-and-so 9/7/2007, religion Hindu, so-and-so, so-and-so, in IDB Marksons. Now, Lordship will find the village and post office. The address Lordship will find, it is post village and post office. Post office is this Silapathar is a town, man. His village is a society village. And wrongly, this letter has been sent in the name of
What is your correct address?
Society Village, Post Office Silapathar.
Where does one find it?
Lordship.
From where is it evident? From which document would you refer that this is the correct address?
My letter here, my post title, Lordship
Where
will
is
find.
your service book?
Maybe there, my letter, and my letter all along since under the Silapathar town, my letter. That
You say this is not the correct address, or this is not the specific address. From which document will you say that this is the correct address where correspondences are required to be addressed to?
that is in the report itself, my letter. Because
No, from which document?
that part, my letter only whatever the documents are they required, my letter.
You have an identity card, you have a PAN card, you have an Aadhaar card or something, some document to show that this is the correct address of my village or my residence. On what basis are you saying that this is not the correct address? This address which they have recorded is perhaps available in the service book.
No, since that part I have to see, my lord, because already I have to find out the identity card.
Your whole case is on the ground that the inquiry proceeded ex parte because the notice which they sent, you did not receive. The notice you did not receive because it was not sent to the specific address.
Yes.
Now you have to show us, it is your burden is on you to show us that which is that specific address where the proper notice ought to have been sent? On what basis will you project it?
Yes. Probably that part I have to bring to the notice of the honorable court regarding this exact this address. And apart from
Is it available, Mr.
It is-
Gupta, in the service book?
My lord, from the records, my lord, if I can see, my lord, it is Silapathar only, my lord, the address which has been given.
No, record.
Service book, my lord,
Record means
Service
you
book
have
also.
the service book.
my lord, I have original records regarding the fact of dissertation, my lord, service book, my lord.
So is your appointment order available here?
it is not enclosed, my lord. My lordship will find at page 20, it's a medical certificate, my lord.
Page 20 also says post office Silapathar.
No, page 20, it's medical certificate, Post Office Silavathar Village Society.
Huh?
Village Society, my lord.
Village
Society,
Society.
lordship. It's my place, my lord. Just my neighbor, door neighbor, my lord.
Hmm?
I also belong to society, my lord. Silavathar.
What is door neighbor?
Just
No, who belongs to?
there, this Sanjeev Kumar's father, my lord.
Who is your door neighbor?
This Dilip Kumar, his father, Sanjeev Kumar.
Huh?
Dilip Kumar Kalwar.
Your father,
Dilip Kumar Kalwar, my lord. This
the father of the
deceased.
petitioner's husband,
Yes.
petitioner's father-in-law.
No, here petitioner Sanjeev Kumar Kalwar
Hmm.
is the now he is deceased.
That's
His
right.
father Dilip Kumar Kalwar.
Ah. So they stay in the same address.
Yes, society.
Society is the name of a village.
Name of the village.
Besides that medical document, any other document?
Page 25 is also there. This is also medical documents.
Don't you have any documents issued by the force to show what address is recorded there? Where is your ID card?
If necessary, I will produce it, my lord.
No,
And-
if necessary means you have to make out a case that this is your correct address and the documents are sent at the wrong address. Referring to a medical document is not sufficient.
And apart from my lord, that part I will produce before losses. And that part, my lord, this honorable court also held, my lord, when there is a deserter, my lord, question of deserter, my lord, the opportunity hearing must be provided. That part, my lord, is lacking. And
See, you are a deserter,
lordship,
you have gone somewhere. Then were you brought back by the force?
my lord, since it was when the address and the communications are with the authorities, and they have also issued a this notice to the police,
Mr. Chetty,
to the police.
what we want to know is,
Yes.
after you are declared a deserter, there was an order to the local police station to arrest you and take
Exactly.
you back. After that, were you brought back to the camp?
I have not been brought back,
Not
back
been
to the
brought back. You also
because
did not come.
neither police came, because all that time, my lord, since 2019, I was under the bedridden, and this all medical this record says, my lord, he was all.
Therefore, your case is that whatever the department did, deserter proceedings for declaring you a deserter, proceedings for dismissal from service, etc., everything was done ex parte. So because you were never served the proper notice.
That address is there, my lord.
Huh?
That address is there, my lord. I have to, then lordship will fix some other date so that I will produce the communication, whatever the identity card is there.
No, so what is your case? Isn't that your case, or is there something else? Why are you challenging this? What is the basis of challenge to the order of dismissal?
Because, my lord, here, it was totally done ex parte, my lord.
That's right.
Yes.
So ex parte, why? Why did you not participate?
Because when the person was under the bedridden, my lord, lordship kindly have a look the documents, my lord. The medical documents, my lord.
No, even if you are bedridden, were you intimated that there is a proceeding going on? Did you have the knowledge?
It has not been received, all this letter, my lord.
That is what we are trying to make you understand, that your case is based on the fact that no communication was issued to you.
Yes, that is why, my lord, in this case, my lord, telephonically it was informed to the authorities concerned in the Likavali, my lord.
Where is that?
In the reply, lordship will find. Reply para 8, lordship. That would trigger the statement made in paragraph 7 of the counter affidavit. The opponent stated that his husband herself was suffering from acute jaundice and was bedridden under the complete medical treatment and advice of the doctor. Accordingly, he was not in a position to inform the authority concerned nor to submit his medical certificate at the relevant time. However, the telephonic message was made to the authority concerned at Likavali about his illness in the month of May 2019 and July 2019 in presence of his deponent.
You were indisposed, you could not participate is one thing, but when were you released from the hospital?
It was
in July.
Let lordship kindly have a look. Let this. I am reading, my lord, this. Para 4. Para starts from para 4, my lord. That the prisoner said around 29/6/2019, he felt uncomfortable as he was suffering from bacillary dysentery with abdominal pain, for which he took the advice from the doctor of Dhamaji Civil Hospital. after the duty hour. However, somehow he could manage to attend the official duty till 3/7/19. While he became serious in the evening on 3/7/19 for his abdominal pain, etc., he could not report for duty. Thereafter, considering his serious problem for his ill health condition, he was treated under the doctor on 5/7/19 at Dhemaji Civil Hospital. And after due treatment, as he found to be acute jaundice, etc., in continuation of his medical treatment, the petitioner's health condition was deteriorated and totally he was bedridden. However, the treatment was continued, found reliefs to some extent, and accordingly, the concerned doctor provided medical treatment dated so and so. The petitioner was advised to take complete rest with continuation of medicines. Accordingly, the concerned doctor in the prescription dated so and so itself found the petitioner suffering from insomnia, amnesia, for which the patient had been referred to psychiatric department for necessary treatment. Accordingly, the concerned doctor issued the medical certificate so and so regarding the petitioner's continuous treatment with effect from 29/6/19 to 24/12/19 at the civil hospitals Dhemaji, as the petitioner was suffering from bacillary dysentery with abdominal colic and jaundice, etc. This copy of the. Now 5, that the petitioner said that subsequently the petitioner who was suffering from insomnia, amnesia, etc., was treated by Dr. Chandan S. Deuri, neuropsychiatry consultant at Assam Medical College and Hospital at Dibrugarh on 2/1/20, who prescribed medicine and advised him to review after 1 month. The petitioner continuously under the treatment and the advice of the doctor on 4/4/2020 and 10/4/20, 10/8/2020. On the transfer of the concerned doctor at Dhemaji Civil Hospital, the petitioner again treated on 11/10/2020 and 13/12/2020 by the same doctor. In this regard, so also issued the certificate dated so stating to be mild depression and sleeping problem, etc. Now, since 2019, 3/7/19 up to 2020, his treatment was continued. First the jaundice, then subsequently he suffered from insomnia, amnesia, which is treated.
So these were not informed to the respondents.
He could not inform at that time. Only, my lord, the subsequently when it was bedridden, he informed to the authority concerned, which was stated in the reply, my lord, in presence of the deponent.
What reply?
In the affidavit in reply. Affidavit in reply, my lord, filed by Anu Kalwar, the wife of the deceased. The para 8 lordship. That with regard to the statement made in paragraph 7 of the counter affidavit, the deponent states that his husband, her husband was suffering from so and so acute jaundice and was bedridden under the complete medical treatment and advice of the doctor. Accordingly, he was not in position to inform to the authority concerned nor to submit his medical certificate at the relevant time. However, the telephonic message was made to the authority concerned at Likabali about his illness in the month of May 2019 and July 2019 in presence of this deponent. This part was done, my lord. Telephonically, it was informed about his illness and continuation of treatment, my lord. My lord, here, this this Honorable High Court, in the similar circumstances, my lord, when there had been deserter, my lord, against the deserter, this some of the petitioner came, one of the petitioner came before this Honorable Court, my lord. And this fact, my lord, by virtue of which was decided in 2008, my lord. Similar facts, my lord. On 2008 2 GLT 394, my lord.
2008. 2008.
2 GLT 394, my lord.
394.
My lord, regarding deserter.
Yes.
My lord, the case of the petitioner, my lord, para 6. Five, 5 and 6, my lord. Just starting from 2, my lord. The present petition has been filed by the petitioner, who is the mother of the late Asim Majumdar, who was serving as the rifleman in the Assam Rifles, a paramilitary force under the central government. The prayer made in this writ petition is to pass the order so and so, whereby it is declared that the claim for pensionary benefits are not admissible as son of the petitioner was declared a deserter and his service stood automatically terminated. Further direction is sought to provide family pensioner thus to the petitioner as the mother of the deceased rifleman Asim Majumdar. Now, rifleman 3, the rifleman son of the petitioner joined service so and so. This is the fact, my lord. 34/97, he was sanctioned leave of the commandant so and so 17th Battalion Assam Rifles for 60 days with effect from so and so. It is pleaded that just before Asim Majumdar was to report back for his duty, he fell sick and applications were submitted seeking extension of his leave. Copies of such leave extension applications sent under certificate post are enclosed so and so. However, it is averred on behalf of the respondent that such applications have not been received by the Assam Rifles authorities. Eventually, the son of the petitioner was detected to be suffering from tuberculosis and he died of the disease on 14/5/1998 without being able to resume his duties. With the Assam Rifles, the petitioner informed about the death of her son by communication dated transfer addressed to the Director General, Assam Rifles, and requested for payment of all dues of her deceased son. In response to the said communication, the petition Director General of Rifles issued the impugn order 29/7/98, conveying the decision that the Asim Majumdar did not rejoin his duty on expiry of leave and remain absent for more than 5 years. He was declared as a deserter, and since he died while declared as a deserter from force, no pensionary benefits are admissible to his account. The claim for family pension made by the petitioner was also rejected by the communication dated so and so 99, issued by the Assam Rifles Directorate to the petitioner. Mr. So and so, learned counsel for the petition submits that the petition was granted so and so so and so. This is the fact, my lord. And now it has been referred, para 7, my lord. The decisions of the regarding all this, my lord. In support of this contention, my lord, the learned counsel for the petitioner has referred to the decision of the Honorable Supreme Court report in AR 1960 SC 492 in case of Jai Shankar versus so and so state of Rajasthan. The apex court hold as follows. The regulation involves a punishment for overstaying one's leave, and the burden is thrown on the incumbent to secure reinstatement by showing cause. It is true that the government may visit the punishment of discharge or removal from service on a person who has absented himself by overstaying his leave. But we do not think that government can order a person to be discharged from service without at least telling him that they propose to remove him and giving him an opportunity of showing cause why he should not be removed. If this is done, the incumbent will be entitled to move against the punishment for. If this plea succeeds, he will not be removed and no question of reinstatement will arise. It may be convenient to describe him as seeking reinstatement, but this is not a tantamount to saying that, because the person will only be reinstated by an appropriate authority. that the removal is automatic and outside the protection of Article 311. A removal is removal, and if it is punishment for overstaying one's leave, an opportunity must be given to the person against whom such an order is proposed, no matter how the regulation describe it. To give no opportunity is to against Article 311, and this is what has happened here. Next, my lord, the para 8. The opposite decision of the Supreme Court in Jaishankar so and so followed so and so State of Assam versus Akshay Kumar Dev, where the Supreme Court followed its earlier decision to conclude that there can be no escape from affording an opportunity to a person whose service are sought to be terminated on the ground of overstaying of leave. And unless such opportunity is provided, the impugned decision of the termination cannot be sustainable in law. The learned consequence so petitioner has also referred to the decision reported in Air 1971 SC 140 Devaki Nandan Prasad versus State of Bihar and others, where the Supreme Court held that even for continuous absence from duties for over 5 years, when an adverse decision of disentitlement of pensionary benefits are sought to be taken, the compliance of the requirement of giving an opportunity in vices under Article 311 of the Constitution of India is mandatory. And in the absence of such opportunity, the impugned decision gets vitiated in law. In this decision, it is further held by the apex court that the pension is not to be treated as a bounty payable on the sweet will and pleasure of the government, and the right of pension is a valuable right vesting in a government servant. The decision of Supreme Court reported in 2003, 12 SEC 578, the State of Union versus Ramcharan, has also been cited to contend that punishment of termination of service only for overstaying of leave is a harsh punishment. This harsh punishment, I have also got your Lordship's judgment in 2024, my lord. I have that judgment, Lordship's judgment. That too against the dismissal.
Give the judgments.
Yes. My lord, 2003 12 SEC 578, that Union of India versus Ramcharan has also been cited to contend that the punishment of termination of service only for overstaying of leave is a harsh punishment. In the present case, deterrent punishment is not called for, since the absence of the petitioner is on account of the circumstances beyond his control, that is his illness, which led to his eventual death. The Supreme Court in Ramcharan case has held that deterrent punishment could not be resorted to when such absence is not deliberate and is not resorted to by a member of the discipline force to avoid and evade undertaking a testing or trying venture or deployment, and deterrent punishment is not warrant in a case of the present facts where the petitioner's son could not resume his duties because of his illness. By citing the aforesaid so-and-so decision, the learned counsel for the petitioner so-and-so Assam Rifles ought not to have declared the petitioner's son to be a deserter and should not have further ordered that his service to be terminated due to continuous desertion, since he was prevented by illness to resume back his duties, and said illness eventually led to his demise on 14/5/1998. Lordship, para 14, Lordship. Before that, my lord, 13. I have considered the submission made by the learned counsel appearing for the both sides from the facts revealed. It is clear that when the son of the petitioner did not resume back his duties after expiry of his leave, so-and-so, by treating absence to be deliberate and willful, the Assam Rifles Authority declared him a deserter with effect so. Therefore, thereafter, it was decided that his service stood automatically terminated because of the continued desertion by taking recourse to the provision so. 14. It is not in dispute that the petitioner's son was not afforded any opportunity by the responding authority before it was declared that his service stood automatically terminated because of the unauthorized absence and desertion. But having regard to the ratio laid down by Jaishankar Supra, Akaksha Kumar Dev, and Deokinandan Prasad Supra, it is clear that there can be no automatic order of termination even in case of unauthorized absence without affording an opportunity to the affected persons. Such opportunity was not made available to the petitioner's son before order was passed to terminate his service. Under this circumstance, this court is left with no option but to declare the action of the terminating service of the son of the petitioner by the Arsenal process to be legally not sustainable. Now, to examine the quantum of the punishment inflicted so and so, it is clearly laid down by the judicial interference is called for only when the punishment inflicted shock the judicial conscience and wholly disproportionate to the misconduct alleged. It has been already held by the Honorable Supreme Court in Ramcharan Supra that the overstay of leave cannot be considered to be heinous offense and could not best be treated as a and could at best be treated as a less heinous offense. In the present case, the petitioner's son remained absent from duty so and so from his terminal illness, and eventually he died of such illness on so and so. Therefore, this is a case for not reporting for duty due to exigencies beyond the control of the incumbent concerned, and is obviously not a case for willful desertion or deliberate absence from duty. Under circumstances, the impugned desertion declaration made by this made with regard to the son of the petitioner is held to be illegal, and the same is interpreted by this honorable court by quashing the impugned communication dated so and so, so and so. In view of it is ordered that the responding authorities shall make available all service dues, including the pensionary dues, as much as may be available under the relevant rules on account of Asim Majumdar, the deceased rifleman of the Assam Rifles. However, no arrear wages would be payable for the period he remained absent from duty. While granting such dues, the case of the petitioner's son should not be treated to be that of a deserter or that of a terminated rifleman of the Assam Rifles. This is their matter. Then, my lord,
What is the second writ petition filed for?
second writ petition, my lord, the first writ petition, my lord, is as per the direction of this honorable court. When the second writ petition was pending, my lord, then the person died, and accordingly, I have been instructed to file the second writ petition for pensionary benefit and all. And
What is the judgment you are referring?
the lordship's judgment.
You are saying some other judgment was there. What is
Yes, sir. And my lord, 1998, my lord. 7 SCC. It is judgment.
Yes.
My lord, para 3, 4, and 10, my lord. 1998, 7 SCC, 5, 6, 9, my lord. Dinanath, Santaram, Karekar, and others, my lord.
So in your case, it has been shown to be delivered. It is not a case that these communications were never sent. According to the department, they have sent it. But it was AC tomorrow.
That part, my lord, I will this judgment, my lord, I'm reading.
This judgment is where there was some endorsement saying it is not found. Court held that once is not enough, there must be some effort to trace out the address, isn't it?
And another judgment in the similar circumstances. This is 13 Lordship, 2013. It's a 1998 Lordship will find page para 3, 4, and 10 Lordship.
Yes.
Should I read or need not be written?
No, it's up to you. You want to read, you can read.
P, my lord, the para 3. The respondent was an employee of the appellant. His personnel file and the entire service record was available, in which his home address was held.
Therefore,
Also had been.
therefore, I'm asking for the
That's true, my lord. I will place it.
personal records. Where are the personal records?
Personal records are not available, my lord.
What do you
However,
want
my
to
lord,
read?
in paragraph paragraph 6, my lord, paragraph 6 of the writ petitioner, it is admitted by the petitioner that the father received the show cause notice, my lord, before declaring deserted, my lord, on 19/7/2019, my lord, a show cause notice was issued.
Letter.
A letter was received, sent, my lord, paragraph 6. That is admitted that they have received the.
That is why the phone call was made.
This letter was received that something was happening, but
Para 6.
para 6. Ask the father, why letter dated, memorandum dated 16.
This is after the order of desertion
No,
is
my lord,
passed.
Yes.
before, my
No,
lord.
no. After the
16/7/2019 is, my lord, notice before declaring deserted that you please come. Your son is missing and he's not replying.
But subsequently it was
please-
received.
Now, this is admitted that the father received the same in the month of October through an unknown messenger.
Now, lordship will find.
Now, if it is sent through a messenger, then it must be through a messenger book or a peon book or something like that.
Yes, my lord, it is there in the records. If they have received it. Page 39.
Where is your, what materials do you have, Mr. Gupta, to say that the son resided in the residence of the father? Why did you send it to the father? Why was it sent to the father?
My lord.
It should have been sent to the son.
Yes.
But it was sent, it was received by the father.
Yes, my lord.
So,
They were staying together, my lord, because when
then
the
why
authority.
was it not, were there no directions to the local police station there to arrest him and bring him back? Because he's a deserter, because that is the procedure.
Yes, my lord, that direction was there, my lord, but they have not arrested him and brought it to the unit.
Hmm.
Moreover, my lord, one thing I will just point out for the assistance of the honorable court, my lord. My lord, this is the standing order governing the, my lord, how to declare the process of declaring a person deserted and thereafter how to, my lord, remove the personnel. So here, my lord, if I take, my lord, to point number 6.
Yes.
It deals with, my lord, action by units, authorities to whom desertions are to be reported. So, my lord, this is the first step. My lord will skip the next page. Then it deals with, my lord, convening of the court of inquiry. Then, my lord, there is a process of lodging FIR, apprehension of
No,
deserters.
if you come back to the action by the unit,
no.
authorities to whom desertions are to be reported. In the next page, you'll find there is the SP of the district or the district collector. If the local police was not responding, then
Yes.
you should have informed
It was,
these persons
my lord.
with a request. What are the consequences of being a deserter?
My lord, after declaring a deserter, my lord, a court of inquiry was ordered, wherein he was asked to submit reply. There also, my lord, he did not appear. Then, my lord, will take point number 7. No, this is the steps for termination by way of dismissal and removal. The person subject to the ITBP Act is declared absent and does not surrender or is apprehended shall be deemed to be a deserter under subsection 2 of section 74 and he is liable to be terminated from service by way of dismissal or removal from the service under the provisions of section 10 of the ITBPF Act 1992 read with Rule 18 of the ITBPF Rules 94 or section 11 of the ITBPF Act 1992 read with Rule 20 of the ITBF Rule 94 as the case may be in accordance with instructions with respect of time period as given below. Note here the date of absence was 4/7/2019. So the steps for removal can be taken, my lord, after 1 year of absence in the following cases. Those who desert while on active duty in the forward areas or while serving with a force engaged in operations or in order to avoid such service, those who desert with weapon or ammunition, those who desert due to suspected subservient espionage activities, those who commit any serious offense in addition of desertion, those who have proceeded abroad after desertion. Clause B, after 6 months of absence, public desertion in other cases. Now, clause C says not that the period mentioned in
Was
para A
any
and B.
paper publication made?
No paper.
Paper publication?
Paper publication, my lord. I have. Lord, one thing, Lord,
It was just the communication, no paper publication.
no, this we have requested, but paper publication was made, but my lord, the copies of the paper publication, my lord, we have asked for the copies, but we have not received. Next page is the request for paper publication, my lord, 10/10/19.
Why are you showing us your communications? Whether it was done or not, that's the instructions required.
My lord, that copy I have, my lord, the communication reflects that
Is there any confirmation that yes, it was published on so and so paper?
that I have to take instruction. But I tried to find out, my lord, but this is what I have, my lord.
Mr. Chetri,
For section 73, Lordship, section 73 of the Indo-Tibetan Border Police Force Act 1992. capture of the deserter. 73. Whenever any person subject to this act deserts, the commanding officer of the unit to which he belongs or is attached shall give information of the desertion to such civil authorities as is, in his opinion, may be able to afford assistance towards the capture of the deserter. And such authorities shall thereupon take steps for the apprehension of the said deserter in like manner as if he were a person for purpose apprehension. A warrant had been issued by a magistrate and shall deliver the deserter when apprehended into force custody. Nothing has been done, and even the police, my lord, this police station is half kilometer from the house of this petitioner.
Whatever it may be, supposing it has not been done, then what is to be done? There is a procedure laid down.
No, when my lord, this has been done, this honorable.
There is a standing order. Do you have a copy of the standing order? Share it with him. You should bring it on. record.
This one, my lord.
Standing order 26/6/2014.
Yeah, yes, ma'am, the one I have, yes.
Yes.
It was understanding.
And 2, any police officer may arrest without warrant any person reasonably believed to be subject to this act and to be deserter to be traveling without authority and shall bring him without delay before the nearest magistrate to be dealt with according to law. Inquiry into absence without leave. When any person subject to this act has been absent from duty without due authority for a period of 30 days, a court of inquiry shall, as soon as practicable, be appointed by such authority in such manner as may be prescribed, and such court shall, on oath and affirmation administered in the prescribed manner, inquire respecting the absence of the persons and the deficiency, if any, in the property of the government entrusted to his care, or in any arms, ammunition, equipment, instruments, clothing, or in necessaries. And if satisfied of the fact of such absence without due authority or other sufficient cause, the court shall declare such absence and the period thereof, and the said deficiency, if any, and the commanding officer of the unit to which the person belongs to or is attached shall make a record thereof in the prescribed form, prescribed manner. If the person declared absent does not afterwards surrender or is not apprehended, he shall, for the purpose of this act, be deemed to be deserter. But here, the action only pen and paper that has been done, and there is no positive action regarding apprehending or taking information about the absent or about the deserter of the persons. Since the person is within the half kilometer of the police station, madam, and this is also nearby the road, the PWD road. It's less than half kilometer. Nothing has been done. Only in pen and paper they have done it, and they are saying that this process has been followed, and accordingly the deserter has been declared, and consequently this removal order has been passed.
All right.
And in such respect, my lord, this decisions of this honorable court, since I'm reading out, my lord, this para 3 and 4 of this 1998 7 SEC, my lord.
You have read that.
Yes, little bit, my lord. The respondent was an employee of the appellant. His personal file and the entire service record was available, in which his home address was also had been mentioned. The charge sheet which was sent to the respondent was returned with the postal endorsement not found. This indicates that the charge sheet was not tendered to him even by the postal authority. A document sent by registered post can be treated to have been served only when it is established that it was tendered to the addressee. Where the addressee was not available even to the postal authorities and the registered cover was returned to the sender with the endorsement not found, it cannot be legally treated to have been served. the appellant should have made further efforts to serve the charge sheet on the respondent. A single effort in the circumstances of the case cannot be treated as sufficient. That being so, the very initiation of the department proceeding was bad. It was ex parte even from the stage of the charge sheet, which at no stage was served upon the respondent. So far as the service show cause notice is concerned, it also cannot be treated to have been served. Service of the notice was sought to be effected on the respondent by publication in a newspaper. Without making any earlier effort to serve him personally by tendering the show cause notice, either through the office peon or by registered post. There is nothing on the record to indicate that the newspaper in which the show cause notice was published was a popular newspaper which was expected to be read by the public in general, or that it had a wide circulation in the area or locality where the respondent lived. The show cause notice cannot therefore in the circumstances be held to have been served on the respondent. In any case, since the very initiation of the disciplinary proceeding was bad for the reason that the charge sheet was not served, all the subsequent steps and stages, including the issuance of the show cause notice, would be bad. Now, Lordship will find para 10, where the disciplinary.
We have read it, Mr. Chetsi.
Lordship. Now, another judgment, my lord, I would like to refer. My lord, this 2013, my lord. For SCC 265.
If you actually give a list of books, we can take out the printouts without troubling you.
Yes.
What is that, 2013?
2013
Hmm,
for SCC 265.
265.
It was yes, it's. It is.
You have an extra copy?
Yes.
Okay. Yes.
The 10, my lord, the relevant portion, my lord. The High Court has taken the view that the ex parte inquiry held against the appellant could not be faulted as his whereabouts were not known, and has also justified the non-supply of a copy of the inquiry report to the appellant for the same reason. However, the High Court seems to have overlooked that the notice with regard to the department inquiry was sent at the address of house number 147. But the correct address of the appellant was house number 177 and not number 147. Thus, ex parte inquiry and the order of the dismissal passed on that basis where
So what is your correct address apart from the medical documents? On what basis are you showing the correct address?
that part I will produce, my lord. That part.
Huh?
That part I will produce. That is why, my lord, in this regard, when there is a.
No, we are closing it. If you can find anything, you place it before the court. Make a mention. Otherwise, we are.
Yes, and this
We have
lord.
heard you.
Yes, and lordship's order, that is judgment 2024. Everything has been decided with the latest judgment, and at last lordship has said that dismissal is a harsh punishment. 24 and 25, my lord.
Twenty-four, 25.
25.
So your arguments are that he was under treatment.
Yes. Yes, under it. And recently our this 2016, my lord, our High Court's judgment, it is also relevant, my lord. By relying the Supreme Court judgment, my lord. By Honorable Justice Bhaipai, my lord. There's a relevant para 6, 7, 8, 9, my lord. Three, my lord, I'm just reading out the facts.
Yes.
Para 2, the facts for disposal of the writ petition are not in dispute. The petitioner is a Hindi teacher and so and so new high school. The case of the petition is that he was absent from school from 15/9/2007 to 17/3/2010 as he was under medical treatment as a psychiatric patient. The respondent number 3 allowed him to resume his duty by his order dated 30/3/2010 after availing leave on medical ground. He resumed his duty on so-and-so 1/4/2010. However, the respondent number 3 issued the order dated so-and-so, withdrawing the said order 33/10/2010. This prompted him to move WPC for passing of the orders, but a departmental inquiry was initiated against him. In the meantime, the departmental proceedings were held against him for the following charges. He was been absent from duty in the school with effect from since 15 September 2007 till date. He was therefore charged with the offense of violating polluting the academic atmosphere. 2, as he has been unauthorized leave since 15 September 2012 for prolonged period, he was deemed to be guilty of non-devotion of duty. He was charged with offenses involving in police case bearing case number so and so under section so and so. My lord, this relevant para 6. The judgment, my lord, I am relying, my lord.
Yes.
The apex court in Krishna Kant V. Parmar, which was also relied by your lordship's order. Let 6th. In the case of the 16th, in the case of the appellant referring to unauthorized absence, the disciplinary authority alleged that he failed to maintain devotion of duty and his behavior was unbecoming a government servant. The question whether unauthorized absent from duty amounts to failure of devotion of duty or behavior unbecoming of a government employee, government servant, cannot be decided without deciding the question whether absence is willful or because of compelling circumstances. If the absence is the result of the compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence of duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventual due to which an employee may abstain from duty, including compelling circumstances beyond his control like illness, accident, hospitalization, etc. But in such case, the employee cannot be held guilty of failure of devotion of duty or behavior unbecoming of a government servant. 18. If a department proceeding, if allegation of unauthorized absence from duty is made, the disciplinary proceeding authority is required to prove that the absence is willful. In the absence of such finding, the absence will not amount to misconduct. Even after the inquiry is over and finding of so and so guilt is recorded against the petitioner, also he has and should have been given the right to be heard on the penalty to be inflicted upon him. This was separately not done. This is also a part of the concept of reasonable opportunity of hearing, to which delinquent official is entitled. If any authority is needed, I may cite this one. This is 2010-11 SCC 278. This court approved the view taken by the High Court and observed so and so. 7. Under Article 311(2) of the Constitution, as interpreted by this court, a government servant must have a reasonable opportunity not only to prove that he is not guilty of the charge level against him, but also to establish that the punishment proposed to be imposed is either not called for or excessive. The said opportunity is to be the reasonable opportunity, and therefore it is necessary that the government servant must be told of the grounds on which it is proposed to take such action. See the decision of the court in the state of Assam versus Bimal Kumar Pandit. Here so and so. If the grounds are not given in the notice, it would not be, it would be well nigh impossible for him to predicate that that is operating on the mind of the authority concerned in proposing a particular punishment. He would not be in a position to explain why he doesn't deserve the punishment at all, so and so, so and so, in excessive. If the proposed punishment was mainly based upon the previous record of the government servant and that was not disclosed in the notice, it would mean that the main reason for the proposed punishment was withheld from the knowledge of the government servant. It would be no answer to suggest that every government servant must have had knowledge of the fact that his past record would necessarily be taken into consideration by the government in inflicting punishment on him, nor it would be an adequate answer to say that he knew.
Alright. Mr.
And lastly, my lord,
We have
yes.
read it.
Lastly, my lord, it has been said, but where he has been given opportunity, the point is not whether his explanation would be acceptable, but whether he has been given opportunity to give his explanation. We cannot accept doctrine of presumption knowledge or that purposeless inquiry, as their acceptance will be subversive of the principles of reasonable opportunity. We therefore hold that it is incumbent upon the authority to give the government servant at the second stage reasonable opportunity to show cause against proposed punishment, and if the proposed punishment is also based on his previous and punishment so and so, or his previous bad record, this should be included in the censure. This proposition laid down in the above noted judgment represent one of the basic canons of justice, that no one can be condemned unheard, and no other prejudice affecting the person can be passed. Censure.
Yes.
And this fact, my lord, here it has been, this complete relief was provided by setting aside the removal, and only, my lord, here, this person, he is no longer now. Only the wife and two minor sons are there, my lord. And now these officers are telling that NOP. And now they are providing NOP per month 5,000, my lord.
What is NOP?
Okay, seriously.
That is, my lord, as per the new pension scheme, my lord, and it's on the annuity, my lord, the fixed amount is.
Annuity.
Annuity.
Ah.
That is, my lord, provided.
And now only 5,000 has been provided per month. And they said, my lord,
How many years of service has he put in?
from 2007, my lord.
2007, and he was
19. The
terminated
incident,
in
it's more than
12 years.
12 years.
what is the pensionary?
Pensionary, my lord, now they are saying that if otherwise this honorable court consider, then they will give the regular pension, my lord.
What is the minimum period for?
There is
qualifying
also
period
10
for
years, my
pension?
lord, 10 years,
10 years, my lord.
10 years.
10 years. Anything you want to submit, Mr. Gupta?
My lord, only regarding, my lord, the process of declaring deserter, and that has been, my lord, followed, my lord, barring that we could not produce this newspaper publication. My lord, the records, my lord, clearly reveals that, my lord, after the period of absence from 4/7/19, my lord, notice was sent to the father on 16/7/19, my lord, from the records, and it was received by the father on 19/7/19. Thereafter, my lord, following the process, apprehension roll was issued, and then, my lord, COI was, court of inquiry was ordered, and he was declared to be deserter. And, my lord, after declaring deserter, a show cause notice was issued.
by making, making a publication in the newspaper, and thereafter an order of removal was passed. Lord, one thing just I may point out, my lord, as a officer of the court, my lord, that the rule says, my lord, that the process of termination should be, my lord, done after 1 year from the absence. My lord, here he was declared absent on 4/7/19.
Yes.
So that is one, my lord,
4/7/19.
4/7/19.
Hmm.
Can you have to say 1 year, no?
No, it would still just.
After 1 year of absence.
Oh, he was absent from which date?
4/7/19.
No,
4/7/19, he was declared absent,
Yes.
deserter.
From that, no, from
3/7.
that date, that is the actual date of absence.
4/7/19.
Yes. On 4/7, from 4/7/19.
Hmm.
Yes.
But termination has to be made after a year.
So after
Termination was on
13/11,
14/11, 2019.
13/11/19, he was removed from service.
Beyond the 1 year.
less than 1 year.
Within the 1 year.
This is violative of which rule?
OM, my lord, which I have given the standing order. Standing order 21/14, which I have produced, my lord. Although, my lord, I am submitting against the department as an officer of the court, my lord, I am pointing out the procedure,
Secretary should be grateful.
my lord.
Yes.
All right. Yes. All right, heard counsel for the parties reserved.
Both the petitions, my lord, 3, 2, 4, 5. Both the petitions.
Both the writ petition lawsuit.
All right. It is your lucky day you got a hearing entirely to yourself.
Congratulations.
Yes.
Lord, can I produce the records also, not original records?
Yes, records.
That, my lord.
Records will be necessary. Please hand it over to the court master.
My lord.
Regular hearing list, item 116.
Otherwise, also Almighty is helping me, my lord. Oblige, I'm sorry, my lord.
Next.
Item 117.
डिस्प्ले किया है कि नहीं? डिस्प्ले हो गया? आइटम नंबर मुझे लोग that displayed original and 117 video